All right. Good morning, everyone. Thank you for joining us for today's Employee Handbook 101 webinar. My name is Paola Garibay, and I am a project manager here on the economic development team with the Berwyn Development Corporation. I just wanted to take a couple of minutes here before we introduce our lovely presenter today, Julie. I'm going to steal her thunder for a bit to tell you a little bit about the Berwyn Development Corporation and the work we do here to support small businesses. So, if any of you are familiar with the Cook County Small Business Source, that is a county agency that we work with. They hire us to help provide free resources to small businesses, many like the free webinar that we're hosting for you today, some business events, and more. So I just want to tell you a little bit about that. So the Cook County Source, again, it is an agency with Cook County government. It's established to help businesses across West Suburban Cook County, Chicago, all of Cook County. We have over 12 business source partners who are ready to help you with any business needs that you may have. It could be anything from an expertise in marketing to business planning. You need help with promotion, event planning. We have these agencies across Cook County that are equipped to help you. So if you talk to somebody like myself here as a business advisor with the Berwyn Development Corporation and you need help with business planning, but maybe that's not my area of expertise, we have someone that we can probably refer you to. So a quick overview, I mentioned of the type of services that we offer for free is business advising. So we do have one-on-one sessions. It can be anything from 15 minutes, 30 minutes to an hour, depending on what your availability is and how much you can commit to spend a one-on-one time with someone to talk about marketing techniques. Maybe how can you enhance your digital presence through a social media campaign? You need help editing your website. We'll sit down one-on-one with you and help you get the tools that you need to help your business grow. There's also a library of resources on the Cook County Small Biz Source website where there are things like business plan templates, access to capital, so different grants that are available, different loans that are available. You can find all of this on the resource page. We host a variety of events across the Source network. This can be from Cook County Source, hosting their webinar Wednesdays once a month, or any of the other partners who are part of this network hosting webinars like the one we're doing today. So like I said, we have a support network, and these are all business support organizations. The Berwyn Development Corporation is one of them. You may notice a couple of names or logos that you recognize here. Some of our partners are the Women's Business Development Center, Illinois Hispanic Chamber of Commerce, the Illinois Restaurant Association. And we partner with these organizations to provide several free business resources to help you grow your business. So if you are already connected with one of these agencies, I encourage you to reach out to them, see how they can help you. But if not, we can get started today. Feel free to reach out to me for any questions or to get started on business advising services. So just a quick couple minutes here. I'm going to go ahead and stop sharing my screen. And Julie, I will let you take over. Thank you so much.
Perfect. Thank you so very much. I appreciate it. It is always a pleasure to work with you. It's always a pleasure to work with the BDC, and I'm very thankful to have this opportunity. You guys have super fun members, so it's a super fun businesses to talk with and interact with. So I appreciate it. Okay, well, let's get started. So the handbook is kind of one of the things that if you are in HR or a business owner, it is like one of the last things that we generally get to. It is just kind of how the world works. You have 1,000 fires going on at all times at the office between employee complaints and getting out payroll and doing the business of the business, that it's one of the things that we tend to kind of let fall to the wayside. And I get it, because that makes sense, right? You have to put out the fires first. But it is also one of the things that can substantially help or hurt us depending upon what's in it. The employee handbook is our contract essentially with our employees. And the policies that we have in it, if well written, are really good defenses for us later on if they allege, that they are entitled to unemployment insurance. You could point to the reasonable rule that they violated, or if they file a harassment complaint, you can point to, no, this was the business expectation, or whatever kind of it is in that regard, it's something that you could point to. It's one of the things that always amazes me is if you go for an unemployment hearing, one of the first things that they will say, if you're contesting unemployment because a person is in no call, no show, they will say, well, how did they know that they had to come to work? And I always just blink as if I'm in like the lights of a truck, because I'm like, how? Because if I don't come to work, I don't get paid. I'm positive that they know that, but you need to be able to point it out. Likewise, when we don't update our handbook, we've got some things in there that are old. For instance, FMLA, the Family Medical Leave Act, it's only applicable if you have 50 or more employees. And it comes with requirements of things that we need to fulfill and obligations for the employer. Well, if you have it in your handbook when you have 55 or 60 employees, but then you dip down to 40 employees and you never take it out, courts have found that you are still required to give everyone all of the benefits and are under all of the obligations of FMLA, regardless of the fact that you don't have 50 or more employees because it's still in your handbook. So the long story short is, I know that, it's something that we tend not to get to right away, but it's something that is important. So that's kind of what we're going to be covering today. And again, like Paulo introduced, my name is Julie Proscia. I'm a partner at Amundsen Davis Law. I've been practicing labor and employment for a little over 20 years now, and have had the pleasure of working with the BDC on multiple occasions. So we can kind of get into it. So when we're talking about employee handbooks, what's the purpose? And I kind of alluded to this a little bit, right? So there are essentially two purposes. One, what are your obligations as an employee? Like, what are you supposed to do? I.e., come to work. What are the expectations of the position? And we want to do this in a way that we set the expectations, but give ourselves wiggle room. It's that little like sweet spot of you generally have to, or we will generally do this, because we almost never, so here I'm going to do it, want to put in we always do something, because there's what I call the idiot nephew exception. And the idiot nephew exception is if we say that that you will be subject to automatic termination if you do X, Y, and Z. What happens when it's your idiot nephew? Of the owner, do you still effectuate the termination? Or what happens if it's your highest producing sales individual? We tend to have exceptions for those individuals. Right or wrong, it's just what it is. It's just what it is. So we will generally say things like we generally up to and including. So we set the expectations, but we also give ourselves a little bit of wiggle room. So the handbook is your first line of defense with your employees. It's your first line of defense when it comes to workers' comp. It's your first, that they are required to notify you immediately of an accident or injury, for unemployment, for wage and hour, that if there's a problem with their paycheck, they have to tell you immediately. They can't just essentially wait in the weeds and not tell us. It ensures that it gives us not only expectations for our employees, but it sets expectations for our managers and our supervisors as to not just the position description, but what they should be doing as far as discipline and documentation. And it gives people kind of the heads up that you will get disciplined if you engage in workplace violence or bullying, or you come in drunk or late, or anything like that occurs, that you can be subject to disciplinary action. So when we're talking about a handbook, I think I said in the beginning that it can super help you or it can hurt you. And courts have found that handbooks and policies regarding harassment and discrimination and other policies have to be clear, concise, and in realistic language, in normal language parlance, in order for it to be utilized as a defense. A poorly worded handbook, or a handbook that's worded with so much legal jargon that nobody can understand it, is not going to be useful at all. And in fact, it can hurt you. So if we make our handbook in normal speak, I mean, yes, there's our legal terms and things like that, but it doesn't have to just be per se and according to this act. Instead, we could just say, Amundsen Davis does not tolerate discrimination in any fashion. And then go on. It also needs to be updated regularly. And I talked about this kind of like giving the example of FMLA, but there have also been a significant number of pieces of legislation that have denoted that you have to have language in your handbook in the past few years. And I am going to go through those, like what do you have to have in here? When I'm reviewing handbooks for my clients, I will usually say things like because they will be like, this thing is getting cumbersome. What do we need in here? And so I will go through and say required, preferred, not required, because I also understand as a business owner and an HR professional, as being an HR attorney, that you don't also want it to be 100 pages long because nobody's going to read that. And then it might legally protect you, but it doesn't actually move forward the needle in the organization. There are some things that when we're talking about handbooks, the question always becomes, well, we've got, we're in 10 different states or we're in 4 different states. What do we do? And I don't think it's really helpful to have a master handbook that has every law in it, because it's super confusing, where it's something like, well, in Illinois, this is your harassment policy, but in Minnesota, this is your harassment policy. But if you're in Chicago, this is your harassment policy versus that of Central Illinois. So what we generally recommend is that you have a master handbook that is something that is specific to everybody. And then we have supplements, which are the extra like 2 pages, which are specific to that state or that region, so that they're only looking at that. It's also important for things like, let's say you have 60 employees in Illinois, so you would be subject to FMLA, but you only have 4 employees in Colorado. And those employees report to a Colorado supervisor, so they're not counted into the total for Illinois. In that case, you wouldn't necessarily want to give them FMLA, so you don't want to have a policy that says, these are what all of the other people get, but not you guys. You know what I mean? So you might want to separate it. I've also, seen where employers will have like an exempt handbook versus a non-exempt handbook, a management versus a non-management, or labor versus professional. Generally speaking, I think that you can have one handbook for all the types of individuals within your organization. You just might want to put things like, for exempt employees, this is, your vacation policy protocol versus that of non-exempt employees. But you could generally have the same handbook for both. So when we're doing our employee handbooks, kind of as the basis to begin with, is policy modification language. These are some of the things that we want in there. And policy modification in language is the part in the beginning where it says X, Y, and Z company reserves the right to alter, amend, or change the policies within the handbook at any time. It's at your sole discretion. You have to give them notice, but that you can change it, because remember, like I said in the beginning, your employee handbook is your contract with your employees. Use plain language. And this is what I was talking about before regarding, like that, make sure that it's something that is that you could read and understand. Have common sense rules, regarding coming in on time, calling in, notice. Be clear and concise, and provide some examples of conduct or disciplinary action. But again, because I'm a lawyer, but not every example, right? So we're going to give the including but not limited to. If you have a large percent of your population that is not proficient in English, then translate that handbook into that language. It doesn't mean that if you have one person who only speaks Polish that you need to translate the handbook into that. But if you have 30% of your population, or 30% of your, or 20% of your population that only speaks and reads Russian or Spanish or whatever it is, it really behooves you to translate it, because it's very hard to argue that they fully understood it if it's not in their native language. Always include the handbook acknowledgement page that they have to sign. And that can be either electronic or via handwritten, via written signature, but always include an acknowledgement that they understand, that they have read and understand. It doesn't matter if they actually did read it and understand it, it's that they acknowledge that they did. Again, contract disclaimers. We're going to put in there that it's not a contract. it's a contract, but we're still going to put in there that it's a contract. We're also going to put in there that who has the ability to bind or alter or change the policy, that, unless it comes out officially through HR or through the president, that those are the only individuals that could change the policies and procedures, that it can't be just, a random supervisor that's going to completely change everything. So let's start going through the policies that you have to have, that you should have, that are required to have, so that we could kind of get an idea of where we need to go with this. For non-discrimination policies, and I'm going to start off with those. So what I did was I kind of broke up the policies that we need to have into different sections, so that it kind of keeps it organized within our heads when we're talking about it. And these are also kind of where we would put within our handbooks, that we would kind of clump these type of policies together. So you're going to have your EEO policy, and your EEO policy is essentially the language that talks about how X, Y, and Z organization doesn't discriminate based off of and then it's going to insert the protected categories in the hiring, employment, termination, and all other decisions in between for the organization. It's also going to have your harassment policy. In Illinois, harassment is based off of either real participation or inclusion in a protected category, or your perceived inclusion in a protected category. That's different than in other states. I included some of the protected categories and denoted Race Crown Act because that's recent, as well as genetic information because that's also quite recent. In 2025, on January 1 of 2025, we also have to include familial responsibilities in there as well. So what we generally do is we list, because you're not going to update your handbook every 6 months when things change. That's just the reality of what's going to happen. Some of my clients are able to do it every year. That's the goal, but that's not, and that's the most ideal, but that's not what happens necessarily, because again, life happens, we get busy with other things. So we tend to wait until something big happens within the organization, or something big happens on the exterior with legislation that requires inclusion. So for harassment policies, your harassment policies should talk about what they need to do if there's harassment or discrimination, who they would report it to, and the types of harassment and discrimination. And again, with the caveat language, we will list out the different types of protected harassment and discrimination, and then put the caveat of, as well as any other protected category that's protected by federal, state, or local laws. Then that way you don't have to change it when things like familial responsibilities come forward. We're also going to talk about sexual harassment, which is very similar to, but not the same as, discrimination and harassment, and what some examples are of that. We also need to list out disability and pregnancy accommodations. So what happens if somebody is alleging that they're disabled, or if somebody comes to us with pregnancy? The handbook, for clarification, is your policy. It's not your procedure. So and there's a big difference between those two. So your policy is going to lay out, we do not discriminate against individuals based off of their status as individuals who are alleging disability, or individuals based off of their pregnancy status, or individuals based off of their religious beliefs and requests for accommodations. Individuals who believe that they have a disability, pregnancy, and or religious accommodation request should immediately contact HR. So that's what we're going to put in the policy. The procedure of, this is the form you fill out, this is what we do when we contact the organization or the leave administrator that we utilize, or whatever it is in that regard, that is separate. That's our procedures, our procedural manual, or internal to HR and with our supervisors. This is just the broad picture and where they go. As in the federal court, and federal legislation have transparency laws and Equal Pay Act laws, which are really requiring that we are cognizant of, are checking to ensure that we are paying individuals equally based off of their sexes. Now, this is for individuals who are in the same position and who are performing the same level and type of work. So we also want to make sure that we have equal pay language in there. And where do they go? That's one of the keys for employee handbooks is if you believe that you are being discriminated against because of your gender or gender identity, and that is resulting in a what you believe is a pay inequity, or you want to request an accommodation, this is who you go to. This is how you file a complaint, because we do not want people to come back later on and say, I had no idea where to go. I had no idea who to talk to, and that's why I didn't do it. We can use that as a defense as a company to say, we gave them a hotline. We gave them the ability to file a complaint online. We gave them ability to go to HR. We have an open door policy. It's in the employee handbook. It's on our intranet, and they didn't utilize any of those resources. So how would we be able to cure it? And that is a very valid defense. When we're talking about our anti-harassment policy, in specific, we really need to list things like, what are some examples of conduct that could be considered harassing? Again, we don't list every single example, but some examples. Where are the sources that it comes from? And this is one of the requirements from Chicago, that it's under the Chicago Human Rights Act. It's under the Cook County Human Rights Act. It's under the Illinois the Illinois Human Rights Act. These are your protections. What are you protected against? Not just harassment, but against retaliation. That has to be listed in there. The requirement in the state and in Chicago is that we also list a complaint procedure. We also have to have now the copy of the poster for pregnancy rights and sexual harassment and discrimination included in our employee handbook. And that's something that we didn't have to do a few years ago. So that also needs to be included. And I always get my clients when they're looking at their like, why do I have to put up the poster and put it in the handbook? And I'm like, because the state says we do. So that's why we have to have that in there. Remember, and this isn't in the handbook, but we are also required to do annual harassment training that is on the state level is the 1 hour training. If it's the city of Chicago, then it's also management, 1 hour of manager training, 1 hour of employee training, and bystander training for everybody. So 2 hours for managers, 1 hour for employees, and then bystander training for everybody. And that's annual. For accommodation policies, when we're talking about accommodations, it's ADA, which is the Americans with Disabilities Act. That's applicable. The Pregnancy Workers Fairness Act, the Illinois Human Rights Act, and then the Chicago Human Rights Act. And pregnancy and accommodations can be things like a closer parking lot, a ergonomic chair, a stand-up desk, and altering a time schedule so that an individual could leave a little bit early so that they could go to PT. We need to make sure that our policies are updated to include pregnancy accommodations and any type of pregnancy-related accommodations. Courts have, and this has really been, subsequent to 2020, 2021, have become much more hyper-focused on religious accommodations and requests for accommodations. So we need to also make sure that we have that in there. I also like to put in there non-FMLA leave as a reasonable accommodation. So it's not, so even if we aren't eligible for FMLA, under the Pregnancy Discrimination Act, time, and under the ADA, time can be a reasonable accommodation. So think of it like if somebody just needs a couple days off to beyond FMLA to finish up their leave, to finish up their last few days of PT, you're not going to terminate them and say that their leave is expired. Or if somebody has to go on bed rest early, ADA might be an accommodation for that because it's medical, but it also might go under the Pregnancy Workers Fairness Act. So in our heads, when we're giving examples of what accommodations might be, because you don't get every accommodation you ask for, but what accommodations an individual might be ineligible, they include but are not limited to time off. When we're talking about handbooks, we've got the discrimination laws, which is also includes our accommodations, our ADA, our medical, but we are also talking about our work rules and the NLRB. And so kind of like shifting gears and going a little bit forward or going a little bit backwards. In 2023, in August of 2023, there was a decision that came out at the NLRB called Stericycle. And I'm not going to go into this in huge length because, like, trust me, we could have like a 2-hour presentation and a drink fest on how horrible this was for employers. But essentially, what it did was it found that work rules cannot restrict an employer's protected concerted activity. So we have to be very careful about what our disciplinary records state or what we can discipline for things like when we talk about equal pay, that you can't talk about, well, you couldn't do this under equal pay anyways, but that will discipline individuals for talking about their salaries amongst each other, or for talking about any type of, or getting into arguments with their supervisors, as long as it is based off of work. It doesn't mean that they get to deride or swear at our supervisors, but we need to be really careful. So the framework that it put under, because they're saying, like, if we're talking about how this place sucks and you are treating everybody poorly, that you couldn't necessarily fire somebody for that or discipline somebody for that. So we need to make sure that our handbook, when we're looking at it, has some NLRA Section 7 disclaimers, but also make sure that our disciplinary policies and our work rules, even when it comes to things like our harassment and discrimination policies, are ensuring that that an individual wouldn't interpret them to be coercive, that there's not this, that we're able to rebut any type of presumption that we are chilling an individual's speech as far as work rules go. So when we're talking about the Stericycle and we're talking about impact, we're kind of thinking that in light of not just our work rules, but our policies and our procedures. And so when we're looking at that, that includes things like our attendance and our time policies. So like kind of the next big chunk that we have are our policies and procedures. We've got our no fault attendance policies and procedures. We need to be a little bit careful about this, how those are written, that they don't run askew of our Chicago Sick and Safe Leave policies and procedures, or our Paid Leave for All Workers Act policies and procedures. What do we do when there's emergency closures? FMLA. FMLA is applicable if you are over 50 employees within a 75-mile radius, or, and this is a big thing, if you have employees that are remote, don't know why I couldn't pronounce that, remote employees that report into your office, those individuals are also counted in your 50 employees. So whether you have 50 employees in a 75-mile radius, or you have 50 employees outside of a 75-mile radius, they're remote and they are reporting into that office, they would count towards the total. Individuals are eligible for FMLA if they work for the company for 1 year and 1,250 hours. We also tend to put in there things like medical leaves of absence, and those would be under ADA, and it's not necessarily a separate leave of absence, but it's something like where we're talking about ADA and where you report and request accommodation, that time can also be an accommodation. Most employers, and this is not required, this is a some employers have in there, have discretionary leaves of absence. This isn't necessarily for something that qualifies as a medical leave of absence or a leave of absence under FMLA, but this is more so that, an individual wants to take 3 months off to go visit their mom in India, or a month off to visit their mom in India, and it's just a very long trip. and they only get 2 weeks vacation. So you might give somebody a discretionary leave of absence, unpaid or paid, for another 2 weeks. Bereavement leave. Illinois now requires, particularly under CBLA, the Child Bereavement Leave Act, that we have language in there regarding bereavement leave and the time off that individuals have. Likewise, we now have to have language in there regarding military leave and family military leave under the Illinois and the Federal Military Leave Act. Paid Leave for All Workers Act or Chicago Paid Leave Sick and Safe Leave Act. That language has to be in there depending upon what you're under, whether you're under Chicago or because you're in the city proper, you're under Cook County, or you're under the state under the Illinois Paid Leave for All Workers Act. Language has to go in there with the policy. Witness and jury duty leave. So that is something that isn't required to have in there, but that you probably should have in there. What do you give for witness and jury duty leave? How do they, how do they report it? Who are they supposed to report it to? Vacation. And that dovetails and ties back into the Illinois Sick and Safe Leave, Chicago Sick and Safe Leave, Cook County leave, and or Illinois Paid Leave for All Workers Act, whether it's separate or included. Sick days. Do you have sick days that are separate and distinct from the Chicago Sick and Safe Leave Act if you're under that, or personal days? Holidays. What, if any, holidays do you have? And are there any requirements for taking the holidays, i.e. you need to work the day before or the day after? I have seen layoff and recall in there. I do not particularly like that and do not put it in there. It's not required, but you can have it in there. Just remember, and that's kind of why I put it on there, just remember, if you have it in there and you say that, and you're not a union organization, let me give the caveat, let me back it up and give a caveat, is if you have individuals who are subject to a collective bargaining agreement, this employee handbook must have the disclaimer in it that the collective bargaining agreement supersedes any policies and procedures if there's a differentiation between the two. And you are required as an employer to bargain all terms and work rules with the union that you have. Okay, so going backward. So for 6, layoffs and recall, if you put in there something like, if an individual is laid off, they will be recalled in the next 6 months, that's your contract, like I said before. So if you are not required to do that because of a state or federal contract or grant, or not required to do it because of a collective bargaining agreement, I tend not to, tend to recommend that you don't include that in there. I think it's really important to have job abandonment in there. So this goes with your attendance policy. This is the 3 days no call, no show is considered job abandonment. This is incredibly helpful in order for you to be able to argue that somebody should be ineligible for unemployment insurance. Unpaid leave due to domestic violence and sexual violence. So this is VESA, the Victims Economic Safety and Security Act. This is required to be in your employee handbook. And it's applicable, and the changes that came into play with VESA this year is that it's also expanded to not just victims of domestic violence, but individuals who were subject to a crime. And it's expanded, or it includes employers with 50 or more employees where they would get 12 weeks of unpaid leave, employers with 15 to 49 employees, 8, and 1 to 14 employees, 4 weeks. So individuals would be eligible for leave regardless of how small you are versus large that you are. And this is unpaid leave, and that policy needs to be in the handbook. I know, I can hear everybody thinking my mind is spinning, this handbook is going to be huge. And they are. Back in the day, because I feel like I'm old, I used to say, if your handbook is more than 25 pages, take a BIC to it. Now it's poof, your handbook's more than 60 pages, because it's super easy to get to 40 pages with the requirement that you have the posters in there, VESA, FMLA, Paid Leave Act. They're just, the policies kind of add up. When we're talking about the leaves, I'm not going to go into in detail because right now we're kind of just covering what to include in there, the differences. But I did want to have in here just that there are 3 leaves that we talked about, and it's the Illinois Paid Leave for All Workers Act, Cook County Paid Leave Ordinance and City of Chicago Paid Sick and Safe Leave Act. If you were grandfathered in, if you put language in your agreement, in your vacation policy or sick policy last year, then you could be grandfathered in. You have the grandfathered in language in and do not have to follow the Chicago Sick and Safe Leave Act because you're complying with the Pay Leave for All Workers Act, unless and until you change your policy. If you did not grandfather in before December 31st, then you are required to follow the act, the Chicago Sick and Safe Leave Act or the Paid Leave for All Workers Act, or Cook County if your county hasn't, if your city has not opted out, which is a whole big mess. And we can, we'll cover we could cover that separately if we want to talk about it, or feel free to call, email, or text me if you have any questions about them in specific, like for your particular organization. But generally speaking, it's 1 hour of paid leave and 1 hour of sick leave for every 35 hours worked in Chicago. And that leave can be used for any reason or no reason at all. In the state level, it's for 1 hour of leave for every 40 hours worked. So it accrues a little bit different. So some of the common mistakes that we see when we're looking at the leaves and how we're talking about things like vacation and sick is to have confusing accrual systems. And there's different type of ways that you could do it. You could do it accrual. You earn 1 hour for every 35 hours work, or you get it essentially as on January 1, you get 2 weeks of vacation, and that you could use that at any time. And there's differences for how you would want to do things. If you get it all at once, that's great, because then if you're seasonal or if you have really high seasons, you kind of make sure that you're spreading it out a little bit, versus that if you have to accrue it, it makes it so that individuals tend to, particularly if you don't front it, or allow individuals to essentially borrow against their time. Individuals aren't taking it in the first quarter. When we're looking at which system we want, I generally go through with the employer and talk to them about, do you have a consistent workforce? Do you have high turnover? If we're in the hospitality industry, we tend not to want to front load a bunch of time because the individuals can leave the next week. We have higher turnover versus that of individuals where they're like, well, we've got people who stay here for 20 years and we've had no new hires in 5 years. Well, then it's okay to front it because you're not worried about that volatility as much. Do we have use it or lose it? If we have use it or lose it, there have to be some caveats with that. If we're doing it on an accrual versus a front loading under the Chicago Sick and Safe Leave and the Paid Leave for All Workers Act, do we specify a rate in there? Because if we're allowing for carryover, how does that work? Because if they earned it at a lower rate, are they getting paid out at a higher rate once they get a raise? How does that work? Sick days. What are we doing for sick days and how do we want to incorporate it? Remember, there are different states and different localities that have different rates for how we are to do sick days. Holidays. Who's eligible for it? How do they become eligible for it? Do they have to work the day after, the day before? Compensation policies. For compensation policies, this includes what your hours of work for, giving you a little bit of time. What are your timekeeping requirements? It is really important to put down who is eligible for overtime, who is not eligible overtime, what happened, and what should they do if there's improper deductions from their salary. We want to make sure that they say that if they see a discrepancy in their pay card, in their paycheck, that they have to immediately contact us. We want to make sure that they say that we say that so that somebody doesn't essentially wait in the bushes and say, oh, I didn't notice that I was being underpaid by $300 a week for the past, 4 weeks or the past 4 years. Meals and overtime and rest periods. We want to make sure that we put in there that if they are a non-exempt employee, that they have to take a, whatever it is, 30-minute meal break and 2 15-minute breaks, or whatever it is we're giving them, an hour meal break every single day, that they are required to clock out, and that we are enforcing that. As of January of 2024, we're required to have travel and expense reimbursement language within the handbook. And again, the wage complaint procedure goes back to the improper deductions. We need to put in there where they need to go. Putting that in there saves you so much of a hassle later on for purposes of having individuals know to come to you, and then later on, instead of later on going to the Department of Labor. Pretty much my goal in life is, it's like Vegas. What happens in Vegas stays in Vegas. What happens at the company, I would really like the opportunity to cure first internally before you go to the Department of Labor or the EEOC or the IDHR or the, whatever organization it is, the IRS. Some of the common mistakes that we see regarding compensation are not having policies about unpaid work, not designating that there's a difference between non-exempt and exempt employees, and we don't have to put exempt employees don't have to clock in and clock out, but we do need to put non-exempt employees. We do need to make sure that we're not doing things like requiring direct deposit. You can't do that. You can give a preference for direct deposit, but you can't require that individuals give direct deposit. You can't make any deductions for an individual's paycheck without having them sign off on it. Things like, you can't economically impact somebody. You can't deduct from somebody's salary if they break something at work, or hold somebody's paycheck if they don't return their computer. You can't, and I wouldn't, promise a pay increase every single year, because that's going to be subject to the economies of your organization. If you have a really great year, then maybe you'll give a pay increase, unless you're union. That's different. That's governed by your CBA. But I would say things like the bonuses or pay increases that, they are assessed on an annual, if you're going to put anything in there, that they're assessed on an annual basis based off an individual's performance and the overall performance of the department and organization. Some of the things that we've been seeing a lot of are individuals who are not getting reimbursed for vehicles, for any type of, like if they have a home office, that you're requiring them to have for the equipment within the home office. Kind of one of the next sections that we have are hiring, promotion, and termination policies. So background checks, I do not put within the employee handbook, because this is for your employee handbook, is for your employees. You have already hired them. They don't need to be in there. Reference requests, there doesn't need to be anything in there because you've already hired them. So that's why I put those two in there, because these are things that if you have in there, you can remove. Performance appraisals, put in their language, if you're going to put anything in there, is that we generally conduct performance appraisals on an annual basis. I want you to conduct them on an annual basis, but what I don't want to say is that by October 15th of every year, we will conduct performance appraisals. Dictate that your managers do that, but once you put it in the handbook, then you're required to follow that. Promotions and transfers, if you're going to put that we generally promote or transfer from internal, make sure that it's general and not that it's required to do so. If you're going to have language regarding the Personnel Record and Review Act, which we have to beginning in 2025, it's the procedures, or we could have that in a separate procedural manual as to what they need to do if they want to request reviewing their personnel file. For termination of employment, I do not put language regarding what severance they get or a specific amount of severance. If you want to have an internal process of how you do that, that's great. But when you put it in your handbook, you're required to do that. And what if the reason that we're doing the terminations or the severance, the separations is because we don't have any money within our organization? We're a nonprofit and we lost all of our big grants. And then we can't say that we're going to pay you for 6 months if we don't have the 6 months of money. Background checks, I just wanted to give information about how we have to consistently do background checks. And again, this is not part of the employee handbook, but we need to make sure that when we're looking at background checks and criminal background checks, that we're looking at it individually and not as a broad sweeping requirements. Again, there's changes with the Personnel Record and Review Act for how often we have to do it, twice a year, reasonable. I just kind of wanted to highlight that. But again, you're not really going to have that in detail within your employee handbook. employee benefits, for things like employee benefits, health insurance, short-term, long-term disability, 401k, for those 3 items, I put a little bit in there that says that the employer gives health insurance, short-term, long-term disability, 401k, and then I say, see the benefits policy, because those documents are governing. I don't put language in there regarding COBRA or workers' comp because, well, let me phrase it. I don't put language in there regarding COBRA because that's something that they get after they're separated from the employment and required. It's not required to be in the handbook. Workers' comp, you don't need to put that they're eligible for workers' comp because of course they're eligible. But what you do need to put in there, or you should put in there, not need, not required, but what you should put in there is that employees are required to report an injury or illness immediately to their supervisor, so that we could say, if somebody comes in 3 weeks later and be like, oh, I hurt my back lifting that 3 weeks ago, you never said anything to us. And it helps us in our discussions with our workers' comp carrier when and if we're contesting it. You are not required to do continuing education within the organization, but if you do continuing education, meaning that individuals will be given like tuition reimbursement, that should also be listed in there. Again, not required to, but have the individuals have it in there. Again, and the kind of little bit more detail regarding the benefit plans, workers' comp, and continuing education. I do not make any of that overly detailed and have separate policies for that. When we're talking about employee technology, that's your workplace monitoring. If you're monitoring it, I'd like to put language in there regarding electronic communication, meaning our emails, our devices, we own and we could look at anything we want. Mobile phone, you can't drive without being hands-free. We have the right to access everything. If you are going to do any type of fingerprint scanning or any type of biometric scanning, then I would have a separate policy, BIPA, that they sign off on. And I've seen it in the employee handbook. It's better than nothing, but you really need to have a separate policy for that. Electronic policy, again, look at it versus what you have and what you want, and that's how we'll do it. There's not necessarily a one size fits all. If you have vehicles that individuals are driving, then we might want to put in there, if we've got monitors, transponders in there saying where they are and where they're going, versus you wouldn't have that in there if you don't have vehicles. Again, BIPA, that's going to be a separate policy. Safety and health plans, these are things that you don't necessarily have to have in there, but you do want to have, I do recommend having something, again, that goes back with the workers' comp, where they report an accident or injury. You don't need to have a smoking policy in there. You can have a sign up. If you're going to do workplace searches, which I do not recommend, I recommend having the police do the workplace search, put it in there. I like having a workplace violence or intimidation language, meaning anti-bullying. I call it like respect in the workplace. If you're prohibiting weapons, we could put that as part of our language regarding regarding requirements within the workplace. Visitors in the workplace, you could put it in there, you cannot put it in there. Sometimes I see it, sometimes I don't. Use of company equipment and vehicles, not required, but again, it's something you could put in there. If you're going to be a drug-free workplace, particularly with things like marijuana, then that has to be either in there or referenced, and then have them sign a separate policy. Common mistakes that you see for drug-free workplace, frankly, are the all or nothing. That we always do this, that we are required to do this, that we require testing. Back in the day, it used to be that if you were in an accident or injury, you could automatically require it. We can't do that anymore. Now, under OSHA, the Occupational Safety and Health Agency, you can only test if there's a reasonable suspicion or belief that the accident or injury was caused by. We could still do things like random, but you have to put it in there and they have to sign off on that. Complaint procedures, retaliation. I think it's good to have an open door. I think that when you're looking at things like your harassment policies and procedures, we want to make sure, again, even if it's open door, that we're not guaranteeing confidentiality, because you cannot guarantee it. If somebody comes in and says, hey, I don't want you to say anything, but I saw that this person sexually assaulted somebody else, but don't say anything. Of course I have to do something. I'm liable to the whole organization. So, we want to make sure that we don't require that. Some of the adjacent things that we talked about when we talked about things like the Stericycle is confidential information. I generally have a separate NDA or confidentiality agreement because it's not one size fits all. What your receptionist has access to is different than your engineer. I have also seen, in addition to the language that talks about like your expectations within the organization, business ethics and conduct policy, there are also some sectors that require that language in there. I think it is really good to have, it's either your business ethics or your conduct, which talks about things like, we expect you to engage in a collegial attitude. We expect you to come to work on time, this would be essentially your code of conduct. Arbitration agreements are not part of your handbook. If you have somebody sign an arbitration agreement, that has to be separate because that comes right when they start. It's not updated annually. And they have to have the ability to opt out on that. Where the employee handbook, they don't give the ability to opt out on that. If they want to be employee, they have to follow the rules, dictates, and sign the handbook. Whew. Okay, so I talked incredibly quick because I wanted to give everyone some time to be able to ask some questions. So I'm going to open it up. I think what we're going to do is stop the recording so everybody can either ask questions in the chat or verbally. And I have put up here my contact information because I went through that at lightning speed, like barely take a breath speed. So you can have the areas, and then we could talk later on if you want to about the specific, policies and procedures and things like that. So I will open it now to questions.
Thank you, Julie. I'm going to go ahead and stop the recording.